So USCIS has always had policy updates, and what they do is if there's been a change to an immigration manual, the USCIS policy manual, which is not like a new memo, that new policy that they're writing the whole thing. They only make updates to it. They tweak it here and there. Then they're going to send an update. So the recent update that came about family-based immigration is called USCIS issues guidance regarding family-based immigration policy. And it was a USCIS release that they sent out on August the 1st, and they actually amended the policy manual in certain ways. And basically, this update clarifies certain requirements for family-based immigrants. It incorporates existing guidance on general eligibility criteria and filing and documentation requirements for family-based petitions, basically requiring more evidence to show that your relationship is real, or else to otherwise decide that maybe it could be fraudulent. They explain how they adjudicate family-based petitions that are filed with related petitions or multiple petitions. They have explained circumstances in which the USCIS is authorizing the Department of State to accept the Form I-130 petition filed directly abroad by a U.S. citizen for an immediate relative, including petitions filed by the military or certain U.S. personnel stationed abroad, and temporary authorizations for large-scale disruptive events. So that part was good, that it gives more clarity on some of those applications filed abroad. Okay, incorporating existing guidance explaining when we will route an approved petition to the Department of State, including circumstances where the beneficiary filed an application to adjust status, but USCIS becomes aware of the beneficiary's inability to adjust. Previously, the government was sending all of those cases to USCIS even though they knew that that person didn't live inside the United States, and requiring the person to file an I-824 to move the case abroad, which was a nightmare and a waste of resources for everyone. So hopefully this part of the update was also beneficial, because ideally the government knows you live abroad. They should just send it to the Department of State in the first place. Clarifying when we require interviews for family-based immigration visas. Family petitions, pretty much as we've seen in this administration, everybody's getting the interview. Most people are getting the interview. And clarifying that we may issue a notice to appear if the alien beneficiary is otherwise removable, since a family-based immigrant visa petition does not grant immigration status or relief from removal. So most of the time, like I said before, most of the time it's going to be people who have a crime, or people who got their case denied, or people who have been accused of fraud. But it could be anyone if the government really felt like it, right? But they can refer people to immigration court even if they don't detain you. They could just refer your case to immigration court if you have only filed an I-130 and you're not eligible for an adjustment of status, or you don't have a second or other parallel status that protects you from being placed in deportation proceedings.